My name is Adeyemi Agbelusi. I'm a dispute resolution professional. I help to advise parties on ways of resolving complex disputes in the most confidential and cost-efficient way. I'm an CEDA-accredited mediator, an IMI certified mediator. I'm also a fellow of the Chartered Institute of Arbitrators and several arbitral institutions, and I work both locally and internationally. I'm the regional mediator for the World Bank Group for West Africa, and basically I do disputes. All right, so my forage into alternate dispute resolution, or more appropriately, appropriate dispute resolution, just stemmed from basically seeing the frustration and the satisfaction of parties with court judgments. And so I witnessed my first mediation session, possibly about 13 years ago, and something changed in me. I took the trainings, and basically it's been no going back. I've realized that alternate dispute resolution is suited for certain kinds of disputes, especially the more personal type. And I see it as a more human and intelligent path to resolution. And so there's been no looking back for me. My role as arbitrator and as mediator are quite diverse roles. However, I think my role as mediator is more challenging because as an arbitrator, I'm required to evaluate the evidence and render a binding decision or award on the parties. So there is structure, there is precedent, there are rules, and of course, there's a process to anchor me. But in mediation, it's a lot more fluid. So I'm dealing with two or more parties who are basically human beings. They're often in real pain, and they're trying to find their way through a conflict. So I need to read the room, I need to manage the parties, and use a lot of legal understanding, psychological insights, and just share patience to guide them. On difficult days, being a mediator is exhausting, but I think it's the most rewarding work I've ever done. I will explain it simply to people as in arbitration, somebody decides for you. In mediation, you decide for yourself. Arbitration is adjudicatory. The arbitrator hears both sides, either orally or by documents, and imposes a binding outcome on the parties, like a private judge. So that outcome is usually binary. That is, there's a winner and a loser. But mediation is facilitative. The mediator guides the parties towards a settlement which they craft for themselves. And the mediated agreement tends to be highly respected because both parties chose it, frame it, design it for themselves. Some people say it's a win-win situation. I don't really agree. I think it's a win-some, lose-some situation. So the parties sort of negotiate an agreement with the help of the mediator and find a sweet spot that they can live with. So the arbitration award, even though most times it is fair, leaves one party feeling defeated. But there is usually more satisfaction with mediated settlement. Now, what's the most common misconception people have about ADR? I think for me, the greatest misconception about ADR is the fact that, one, it makes you weak, look weak, or that you don't have a strong case, or that is for the poor or for minor disputes. In my career, I have handled highly complex state, federal, business dispute running into billions of naira and, of course, hundreds of millions of dollars. And these complex disputes cuts across aviation, shipping, financial disputes, etc. And it's simply the parties knowing that the mediation process is confidential and is without prejudice. which means that your legal rights are suspended. You can go into a room, spend time there, look for an argument, look for a settlement, look for whatever you think will help you to compromise the situation, and then come out of that room with a solution. Now, if the solution occurs, we are all fine. If it doesn't occur, the lawyers can take up their wigs and gowns and go back to court and argue for a decision from the judge or the arbitrator, depending on what your clause says. So for me, the misconception is that, ADR is simply for cases that are very simple or that the parties are unable to have any clarity about the strength of their arguments in court. But I think that opting for ADR is a strategic and intelligent decision that shows maturity, especially for commercial disputes. Sitting down with your adversary in a room and agreeing on some kind of common ground, for me, I think is just the perfect way to go. Have I ever handled a dispute that seemed impossible to resolve? Yes, I have. And it remains one of the most striking parts of my career. I think this dispute involved two business partners in the pharmaceutical industry. They had a large reach of partners and they had a lot of multinationals working with them. And there were years of anger, betrayal, so many accumulated grievances, and a lot of wounded pride. And a very top government official referred them to me that this business cannot go under. How do we resolve it? So we spent a whole month practically doing nothing, just ventilating and showing anger. And I felt at that stage that, look, this has to end up in court. In fact, I had meetings with their lawyers, and I'm like, this is best suited by a judge to partition the business. But there were too many layers of anger and claims that it couldn't be done by any court in a meaningful time. Because remember, this is a commercial entity that is an ongoing concern. So we agreed to do some conflict coaching. And we spent another 2 weeks on conflict coaching. I invited professionals on anger management, emotional intelligence, clear communication, all of that. And I've sort of transformed them into maybe people who can articulate, their grievances. Then went into the mediation. And over the next 9 months, a lot of back and forth, we resolved. And the business was partitioned. A second entity was registered and incorporated. We partitioned the business, partitioned the staff, partitioned the assets and liabilities. And today, those two businesses are thriving. And from my own little investigation in the community of that, that sector, people think that they broke into two to capture the market, to get more market share. That was a strategic decision. But I know that it was a strategic decision not to collapse the business. And I'm happy that the parties had that emotional maturity to take the right path. So yes, that case really formed me. It took some time, and I think it was one of the most rewarding times I had in mediation. So it's really about preparation and perspective. Before any mediation, I ground myself. I am aware of my own feelings, where I am, and then I also check myself and remind myself that my aim is to serve the process and not the outcome. So I don't have a settlement mentality, like I do when I train potential mediators. Mediators don't solve disputes. Parties solve disputes. So while I can say that I have facilitated over 600 cases, I cannot say I have resolved a single one of them. The parties will resolve. So I remind myself that it is not the outcome that is in my hands. It is the process. And so that detachment, paradoxically, is what gives me success. It helps me to be present during the sessions. And when I feel that the room is getting charged or I am getting charged, I step back. I use the structured ways of dealing with this in mediations, like summarizing, rephrasing, and taking a break. And then we come back into the room, and I make sure that both parties and myself realize that their perspectives are equally important. And once that is well communicated, then we know that it's not about who wins or who is to blame, but about how we resolve. So we separate the people from the problem, and we focus on the problem, and we are soft on the people, and we will work for the outcome. So yes, it's a lot of discipline and compassion, but the mediator exists to equally serve people in the room and not get involved. So he needs to remain neutral. Now, what qualities make an exceptional ADR professional? I would say wisdom and patience. Wisdom because disputes arise basically from causes of action. We have that beautiful lady, even though she was not beautiful before, but she's very beautiful now, called Lady Justicia, that is Lady Justice. And we see that she says, ubis juice, when there's a wrong, there is a remedy. So the truth about it is that when causes of action arise, they fall from different areas. It could be recovery of premises, trespass to land, return of title, matrimonial disputes, breach of contract, etc. So a dispute resolver should be able to evaluate this cause of action, filter it, screen it, and see what is appropriate for it. And that takes wisdom. And when parties are also in that conflict, you also need that wisdom to be able to help them think out of the box, look past their arguments, look at the big picture, look at the future, and then work towards that settlement. You also need patience because many times they don't want to do this. Parties come into the room positional, and they believe that I have a breach or I have a defense or there's some negligence or some recklessness. They have so many arguments. But how do we get them to gradually put the argument down and look at the bigger argument that we're in this commercial entity to make profit, or that we're in this relationship to benefit each other? That takes patience. You must be able to hold the room without dominating it. You must have confidence and not be arrogant. And also remember that you're dealing with human beings. So I've taken courses on psychology, behavioral management, NLP, all of these courses, because I realized that I'm dealing with human beings and their emotions are the center of most of these disputes. Most disputes, once you deal with the emotions and the ego, tend to disappear. So wisdom, patience, and adaptability, and critical thinking skills, I think these are all of these things that make for an exceptional ADR professional, and most of all, humility. Humility to realize that resolution ultimately belongs to the parties, not to you. Why do I think ADR is becoming more important in today's world? Well, number one, I work across several jurisdictions. At least I've worked in about 33 jurisdictions, and I can tell you that the court backlog is the same. There's people think Nigerian courts have a backlog. You need to go to some other countries. So there's an enormous court backlog, and there's pressure that runs into years and, of course, cost. And so justice is inaccessible to the ordinary person. So ADR offers speed, confidentiality, expert determination, and of course, it gives you something that litigation cannot match, which is an outcome you can live with. So I find that also people in this age of self-awareness and self-protection also want to have more agency over how their disputes are resolved. So ADR offers this, and so it's becoming more and more acceptable across jurisdictions. Nigeria, I must thank the Lagos Multi-Law Court House, Mr. Kenya Ino, Mr. Rio, and so many of them who pioneered this, is really leaps and bounds ahead, even of England in terms of ADR. Nigeria has done excellently well. We lead the world in this. And I find that with the increasing nature of cross-border disputes, digital business, and fluidity of legal systems in international business, especially, and commerce, people are intending to find resolutions to their disputes that they can enforce across borders. So the Singapore Convention on the Enforcement of mediated settlements, and of course the New York Convention in Arbitration make ADR a very useful tool in being able to take the results of your dispute resolution across borders easily, as opposed to a court judgment. So it's making ADR become more important in the world and more focused for parties as an alternative. What is my most memorable experience as a neutral? Well, I think my most memorable experience was, of course, the celebrated resolving of a matter that was over 40 years in court. It was a family matter. It had gone to High Court, Court of Appeal, Supreme Court, and the parties had been locked in a generation, basically, of disputes. And the siblings had not spoken. There was so much bitterness and anger. Out of about 11 parties, I think at this time there were only about 6 alive. Most of them had passed away. And so we started the matter, and it was very late in the day that we eventually found a way to compromise the situation. And somewhere within the mediation, one of the younger brothers, who was 39 years old, looked at his elder brother and said, I don't even know you. I mean, I miss you. And I think that tone sort of set the stage for the compromise, because that brother sort of calmed down with his anger. Anyway, we resolved the disputes, and the parties turned to me and said, Doctor, you just gave us back our life. And those words have always rang true in my ears, that, dispute resolution really puts people's life on pause. People can't think, can't function. The dispute takes over everything that is their persona. And so when you help them to resolve it, really, you are literally giving them back their lives and giving them an opportunity for a new future. So my memorable experience is that resolution of a 4-decade dispute, and to always remain with me as a reference point in my career. Work hard, get trained, get mentored. I remember many years ago, one of my very senior mentors, legal and in arbitration, Ms. Irad Balogun, said to me at that time, keep working hard. Your appointment as arbitrator will come in about 12 years' time. I looked at her and I was like, she must be joking. Why would I spend 12 years waiting for my first appointment as arbitrator? But those words rang true. Now my diary is full with appointments, and it's well over 12 years. So she was right. She was speaking from experience. An ADR practice takes a long time to mature. Many people want to go for a short 40-hour mediation training, and then they want to resolve the dispute between America and Iran. It doesn't work out that way. You will spend years. You will spend over a decade trying to build your career, to prove your worth. And how do you do this? By volunteering, pro bono, by being in the room. Basically by being in the room. My first arbitration, I served coffee, tea, took attendance, and carried the takeaway food for the counsel to their cars. But you know what? I got to draft a procedural order after that arbitration. And that was really the beginning of being active in the room. So if you are too arrogant and you think that you are bringing something to the room when you actually have nothing, then you can't have mentors who will lead you. So people like Mr. Revival, Mr. Debomire, and Tudebu Sari, and so many other professionals are able to mentor, coach, support my journey locally and internationally. I've had a whole lot of international colleagues from Singapore, from England, from Germany, from Russia, from the US, who have been able to shape my career and help me to build a strong ethical background and also a very professional background. So today I will tell young professionals is that cultivate genuine humility, read about negotiation, read about the the dispute resolution, deepen your legal knowledge, especially in contract law, in the laws concerning obligations. Read court cases, because the more you read court cases and see the ratio of the judges, the more you're able to bring that thinking when you're resolving the room, and also help to formulate issues for determination. I spoke at a function in Paris a few years ago, and a lot of mediators said to me that struck them. What did I say? I said I approach my mediation as an arbitrator, principally looking that in arbitration, once I can narrow down the issues for determination, I can write my award. So in mediation, I bring that skill into the room. No matter what the parties are saying, I have an agenda. I help them to distill the issues, and they will resolve it. So you need to develop so many skills as a mediator, as an ADR professional, from public speaking to emotional management to so many things. So you're spending years developing your career. It's also spending years developing yourself. Attend conferences, publish articles, interview seniors, interview, network. And then when the time is right, boom, the fruit will grow, and then you become an accomplished professional and people want to refer to you.